Welcome to Law Days and Lattes, the podcast where we blend the world of law and business with a warm cup of information and common sense. I'm your host, Sidney Wheelan, attorney, real estate investor, and business owner. Each week, we'll be your go-to source for legal insights, business advice, and so much more. Whether you're a seasoned professional, an ambitious entrepreneur, or simply someone seeking guidance, we'll have you covered. From navigating the legal landscape to empowering you with valuable business strategies, we'll explore the legal side of life and enjoy a virtual latte along the way. So, grab your favorite latte, get comfortable, and let's dive into Law Days and Lattes. Welcome to Law Days and Lattes, sponsored by the Wheelan Law Firm of Moberly, Missouri, your go-to source for legal issues encountered by your family and your business. If you have questions about anything we discuss on this podcast, please reach out to us at www.wheelanlaw.com. Our goal is to serve you, your family, and your business professionally and with the utmost compassion and understanding. I'm your host, Sidney Wheelan. Welcome to episode number 16. Today, we're diving into the world of mediation and how it might be the key to resolving your legal dispute efficiently and amicably. I believe that an understanding of mediation is crucial for anyone involved in a legal dispute. Whether you're in the middle of a civil claim, a family matter, or a commercial conflict, mediation offers a path that could save you time, money, and stress. So, grab a cup of coffee and let's get started. First, what is mediation? Mediation is a form of alternative dispute resolution where a neutral third party, known as the mediator, facilitates a discussion between disputing parties to help them reach a mutually acceptable settlement agreement. Unlike a judge or arbitrator, the mediator does not make a binding decision about your case. Instead, the mediator assists the parties in communicating more effectively, exploring their interests and needs, and then attempting to negotiate a resolution of the disputes. As a practicing attorney with many years of experience in the courtroom, I have had many opportunities to use mediation to resolve cases. While not always successful, mediation gives the litigants an opportunity to resolve disputes prior to risking all and maybe receiving an unfavorable decision by a judge or jury. Often, the parties are able to negotiate more creative solutions which may not be available to them at trial, where there is usually one winner and one loser. I would be remiss in my obligation to my listeners if I didn't tell you that it is important to consult with an attorney both before and during the mediation process. It is equally important to go into the mediation with a collaborative mindset and a willingness to compromise. Understand that if the dispute is going to get resolved, there will be compromises. No one will get everything on their wish list. A typical mediation begins with a discussion about each party's interest in resolving the dispute prior to going to trial. Let me just say that not all cases benefit from mediation. If the parties or their attorneys are so entrenched in their positions and it is a winner-take-all situation, there may be no compromise that will resolve the issues. Those cases are best left to the courts where the judge or jury can and will make the decisions that both parties will have to live with. In my opinion, I believe that there are a lot of legal disputes that are best resolved between the parties themselves, and sometimes this requires the assistance of an experienced mediator that can evaluate the parties' legal and factual positions, offer suggestions, and move the parties closer to an agreement that everyone can live with. I often advise my clients that if they can negotiate an agreement with the other party, it is almost always better than a decision made by a third party that does not know you or your situation, and you must live with that decision, like it or not. Most mediations are completely voluntary. However, some courts, in some cases, will require that the parties attempt to resolve the case prior to trial. In my opinion, court-ordered mediations are less likely to result in settlement than mediations that are initiated voluntarily by the parties themselves, who are interested in resolving the dispute outside of the courtroom. So, how does this process work? The mediation process usually begins with the choice of a mediator, a person that all parties can agree to. Like other professionals, each individual mediator comes with their own personal and professional experiences, styles of engagement, and preferred methods of communication. Many mediators are experienced litigators or retired judges, or other professionals with education and experience in various types of mediation and settlement negotiations. The selection of a mediator is usually a decision made by the attorneys involved in the case, since they are familiar with the legal type of dispute and the pool of mediators that are experienced with that type of case. The availability of potential mediators and the cost involved are also factors to take into consideration when choosing the mediator. Once a mediator is agreed upon, the attorneys for all litigants will work with the mediator to agree upon a time, place, the mediator's fees, and who will initially be responsible for the cost. Prior to the actual mediation, some preparation and planning on the part of all parties enhances the chances of a successful settlement. Most experienced mediators will request a confidential statement from each party prior to the mediation, indicating relevant issues and each party's positions and details of any damages claimed. The mediator may want to review pleadings, photographs, or other information that the parties think are important or are relevant to the case. On the day of the mediation, the mediator will separate the parties into separate rooms with their legal representatives and move between the parties during the course of the mediation. Ideally, the mediator will be assessing the legal and factual positions of the parties, asking questions, suggesting possible solutions, and helping the parties move closer to a resolution that both parties can agree upon. So what are some other benefits of mediation? Well, cost effectiveness, for one. Mediation is generally less expensive than going to court because it involves fewer legal fees and reduces the time spent on prolonged litigation. As a rule, litigation gets more and more costly as the case gets closer to trial. The cost of depositions, cost of paying expert witnesses to prepare and testify, perhaps the cost of preparing exhibits, and yes, let's not forget the mounting attorney's fees as the attorneys prepare for trial. Second, mediation can save time. The mediation process is typically faster than the court process. While court cases can drag on for months or even years, mediation sessions can often resolve disputes in a matter of days or weeks, allowing the parties to move on more quickly than if they were to go through the entire court process. 3. Confidentiality. Mediation sessions are private and confidential. This allows the parties to discuss issues openly without fear of public exposure or the information being used against them in future legal proceedings. Nothing revealed in the settlement talks may be revealed to the opposing party by the mediator without your consent. This allows the parties to disclose background information to the mediator, gives the mediator important insight into the issues of your case, and increases the potential of settlement that will meet everyone's needs. And also, nothing in the settlement negotiations are fodder for the courtroom. If the case is not resolved in mediation, the rules of procedure require that nothing in the settlement negotiations may be used as ammunition for or against a party at trial. 4. Mediation offers control and flexibility. In mediation, the parties have more control over the outcome as they work collaboratively to reach an agreement. This contrasts with court cases, where the judge makes the final decision. The process is also more flexible, allowing for creative solutions that may not be available in court. 5. Preservation of relationships. Because mediation fosters a cooperative approach, it can help preserve relationships, which is especially important in family disputes, business partnerships, and community conflicts. And next, mediation has a high success rate. Many disputes go through mediation are resolved successfully with agreements that satisfy both parties. Rarely do you have that with cases that are decided by a judge or jury. If mediation results in an agreement, it can be formalized in a written settlement. This agreement is binding and enforceable, much like a court order. It can save parties from the uncertainty and further expense of a trial. Next, mediation offers tailored solutions. It allows for more personalized and flexible solutions that a court may not be able to provide. This can result in outcomes that are more satisfactory and practical for both parties. And there is improved compliance. Agreements reached through mediation often have higher compliance rates because the parties are directly involved in creating the resolution and are therefore more committed to upholding it. And as a side note, judges love mediation as it reduces court backlog. By resolving cases through mediation, the burden on the court system is reduced, which can lead to quicker processing times for other cases that do go to trial. Mediation saves time. It can resolve disputes faster than court cases, as we discussed, particularly if the parties and the attorneys are prepared and communicate the facts and issues of the case honestly and completely with the mediator and with their own clients. And also, as I touched on earlier, the parties have more control over the outcome in mediation and flexibility in negotiating terms. Some quick examples. In a case involving money damages, perhaps the parties could come to an agreement on a dollar amount if there was some flexibility on working out a payment plan. Or child support or custody cases. Maybe the parents could work out a flexible plan that works around difficult work schedules or other situations. So, what types of cases are suitable for mediation? Today, we are talking about civil cases. The most common civil disputes suitable for mediation are contract disputes, personal injury claims, and property disputes. Other cases where mediation is appropriate is family law. The role of mediation in divorce, child custody, and other family matters can be very helpful. All families are unique. When we are talking about personal issues that affect one's family, I will often tell my clients that they are in the best position to resolve those issues between themselves, but sometimes it takes the help of a trained mediator. They are almost always in a better position to know what will work and what will be in the best interest of their family over the long term, even if they're having trouble reaching an agreement initially. Leaving those decisions up to a judge that may or may not be familiar with their circumstances, in my opinion, is sometimes not the best choice for their families. Even though the marriage may be ending, there are family relationships that will continue long after the divorce is final, and I think it's important to try to preserve those relationships. Commercial disputes also can benefit from mediation. Businesses can benefit from mediation in resolving disputes with partners, clients, and employees. And again, preserving those relationships can be very important to the parties. Other areas, mediation is not just for resolving lawsuits. There are many other areas in which mediation can be successful in preventing legal claims. Think about community disputes or workplace conflicts. I'm often asked, what if I agree to mediation? What are the potential outcomes? Well, ideally, settlement agreements. Disputes will be resolved, and if so, the agreement will be reduced to writing with all of the obligations of all of the parties clearly defined, and all parties and their legal counsel will have to sign off on the agreement. What happens if the mediation does not result in an agreement and the parties reach an impasse? Sometimes the parties just can't agree. What are the next steps? Well, there are options available if the mediation fails. That could mean that the parties continue to prepare for trial by the judge or jury. That also means that the case might get settled after mediation, but before trial, especially if the parties continue to communicate, stay open-minded, and open to thinking outside of the box for creative solutions. Thank you for listening today. I hope I've opened your eyes to additional options when it comes to resolving legal disputes. If you have found this episode helpful, or if you have questions about mediation or other methods of dispute resolution, please reach out to us at www.wheelanlaw.com. We will put our contact information in the show notes. As a reminder, if you hit the subscribe button, you will automatically be alerted when a new episode airs. If you enjoyed this episode, please give us a 5-star review and share it with your friends and family. As always, my friends, grab a cup of coffee or your favorite latte, hold your loved ones tight, and have a great week.
This podcast episode contains general information for discussion purposes only. Each case is different and must be judged on its own merits. Missouri rules generally prohibit lawyers from advertising that they specialize in particular areas of the law. This show should not be construed to suggest such specialization. Nothing on this show should be taken as legal advice for any individual case or situation. This information is not intended to create an attorney-client relationship, and the listening or viewing of this podcast does not constitute an attorney-client relationship. The choice of a lawyer is an important decision and should not be based solely upon advertisements.